Welcome back to IP Essentials. In episode number 1, we covered the picture, what intellectual property is, why it matters, and the 4 main types. Today, we zoom in on the most commonly misunderstood type of all, that is copyright. Here's something that will surprise you. Copyright affects you every single day, and most people get it completely wrong. They think it's on the internet, so I can use it. They think I gave credit, so I'm fine. They think I changed it a little bit, so it's now mine. Well, all of those are wrong. By the end of this episode, you will understand exactly what copyright is, how it works, how it longly lasts, and how to protect your work and avoid accidentally stealing someone else's work. Let's get into it. So, as on the slide 2, you can see all these topics will be covering today. We will start with what copyright actually protects because it's not everything you might think. Then we will talk about how copyright comes into existence, and the answer will surprise most of you. After that, we will get into the duration. How long does it last? Then about the public domain, what it is and why it matters. Fair use, the concept everyone misunderstands. And finally, we will bust the most common copyright myths. Some of these are genuinely shocking. But before all that, let's start with a quiz. As you can see on the screen, there are 4 questions. Just think about your answer in yes, no, or not sure. Question number 1 says, you post a photo on Instagram. Can someone else freely repost it? Question number 2 is, your friend hums a brand new melody in the shower. Is it automatically protected by copyright? Question number 3 is, you find an old song from 1940. Can you use it freely in your YouTube video? And the last question is, you write a private diary and never published it and never shared it also. So does it have copyright protection? Take a moment and think about your answers. I will give you the answers at the end of this episode. For now, let's build the knowledge you need to answer them yourself. As you can see on the screen, slide 4, which will be covering what copyright protects. So what exactly does copyright protect? Well, the law protects original creative works, things you create and express in a fixed, tangible form. Let me walk through the main categories. Number 1, literary category. So this is the most obvious one. It covers books, novels, poems, newspaper, articles, blog posts, emails, scripts, and even the code you write as a programmer is considered a literary work under copyright law. Next comes music category. Both the underlying composition, the notes and melody, and the sound recording of a song can each be separately copyrighted. This is why music licensing is so complex. Next comes films and video. Well, it covers movies, documentaries, and yes, your YouTube videos also. The moment you hit stop recording and save that file, it has copyright. Next comes artwork. It deals with paintings, illustrations, photographs, graphic designs. All of these are protected under the artwork category. Yes, that photo, that stock photo you copy paste from Google Images, that is also protected. Next comes the software category. Computer programs and applications are treated as literary works. The code itself is protected under copyright. Next comes architecture. Well, even the building designs and blueprints, this is also protected under copyright. So it's a broad categories of works which I have discussed. So if you made it and if it is original and if it exists in some tangible form, copyright likely covers it. Next, we will move on to what copyright does not protect. Now, this slide is equally important, maybe more important, because understanding what copyright does not cover is just as critical. This is a big one. Number one, that is ideas. Well, copyright protects the expression of an idea and not the idea itself. Let me make that concrete. Take an example of J.K. Rowling. J.K. Rowling has copyright over the specific text of Harry Potter, but nobody owns the idea of a young wizard going to a magical school. Someone else could write that story with their own characters, their own words, their own world. Copyright does not stop that. Next comes facts and data. Facts belong to everyone. If I tell you that the population of India is 1.4 billion, well, that's a fact, and nobody owns it. A list of cricket match scores, that is also not protected. Next comes government documents. In India, laws, court judgments, and official government documents are all in public domain. They must be accessible to everyone. The Copyright Act specifically says this. Next is expired works. So once the copyright expires, the work enters the public domain. We will cover this in detail in a moment. And the last one is titles and names. A book title is not copyrightable. A character's name is not protected by copyright either. Now, they might be protected by trademark, which is a different thing entirely. So that will be covered under episode number 3. But that is not covered under copyright. So the takeaway here is copyright protects how you said something and not what you said. Let's move on to the next topic, which is how is copyright created? How copyright comes into existence. Now, here is the part that most of the people don't know, and it changes everything. Number one is copyright is automatic. Well, people say that copyright is automatic the moment you create an original work and fix it in some form. Yeah, it is protected under copyright. But in that case, no registration form is needed, no government office, no stamp paper fee, no other kind of fee. Suppose you write a poem in your notebook. Well, that is copyright protected. You take a photo with your phone. That is also protected. You record a voice memo of your melody. Well, that is also protected. But there are 3 conditions that must be met. Number 1 is originality. The work must be your own creation and not copied from someone else. It does not have to be genius or groundbreaking, but it should be original. Number 2 is fixed form. It must exist somewhere on paper, as a digital file, or as a recording. An idea just floating in your head has no protection. Fix it and it does. Number 3 is automatic. From that moment you have copyright, the law recognizes it. And the last one is registration. Now, while registration is not required for copyright to exist, it is strongly recommended. But why? Because if you ever need to go to the court, if someone steals your work, registration gives you enormous legal advantages. In India, you register with the Copyright Office under the Ministry of Commerce. So the bottom line here is you create it, you fix it, and you own it. Registration is your safety net. Next, let's move on to the next slide. That is, how long does copyright last? So, depending upon the category of works, the duration of the copyright protection is also different. Now, let's move on to point number 1, that is for the literary, musical, and artistic works, the most common type. So, the copyright lasts for the lifetime of the creator plus 60 years. So, if an author dies in 2025, their works are protected until 2085. That is plus 60 years. Now, comes the category of photographs. So, it will also be the same, that is lifetime plus 60 years. Next is for sound recording and films. It has got a different protection, duration, and it is slightly different. What happens is here it is 60 years from the date of publication. So a film released in 2000 is protected until 2060. That is plus 60 years from the publication date. Last is government documents. So in this category, no copyright protection at all because they go directly into the public domain. Now compare this to other countries quickly. Well, in the US, it's life plus 70 years, and in Europe also, it's life plus 70 years. But in India, it is 60-year rule, which is slightly shorter, but the principle is the same. And after all the time, the work enters what we call the public domain, which brings us to the next slide. The public domain is a fascinating concept. When copyright expires, a work does not disappear. It does not get destroyed. It becomes free and available to everyone forever without any permission or payment. Now let's read what is public domain in simple words. So works in the public domain can be used, copied, adapted, sold, or built upon by anyone. Suppose Shakespeare's plays written in 1600s. They are all in the public domain. Anyone can perform, adapt, publish, and translate them, and they do also. Now, here is an important warning. Public domain status can vary by country. So if a work that is in the public domain in India might still be protected in the US, always check the law in the specific country where you plan to use it. Let's move on to our next slide, which will cover fair use and fair dealing. Now we get into one of the most misunderstood concepts in all of copyright law, that is fair use. In India, it is technically called fair dealing. The concept is similar but slightly narrower than the American fair use. Fair dealing allows you to use a limited portion of copyright work without permission for specific purposes. In India, those purposes include private use, research, criticism or review, news reporting, and education. Now, a lot of people hear this and think, great, I will just call everything education and I am safe. That's not how it works. Court looks at 4 factors when deciding if something qualifies as fair use. Number 1, purpose. So, is the use commercial or is it non-profit, educational, transformative? Non-commercial and educational uses are more likely to qualify. Next is the nature of work. Is the original work factual or highly creative? It's easier to quote from factual work like a news report, a textbook, than from a poem or a film. Third is amount. How much did you use? The less will be the safer. But here's the key. Even using a small amount can be infringement if it's the most essential part. Using the chorus of a song, that's the heart of the work, which will matter. Fourth is impact. How does you use that work in the market? Will it affect the originality? So if someone might not buy the original because they get it from you for free, that's a major problem. And the most important thing to remember here is fair use is not a free pass. It is a legal defense. You can only claim it after someone sues you. A court then decides whether it applies or not. So I think this is fair use is not a shield. It's an argument you make in court. So be careful. Let's move on to our next slide, which is myths busted. All right, let's bust some myths. These are the 4 common copyright misconceptions I see. Number 1, it's on the internet, so it's free to use. Well, it's wrong. The internet is not the public domain. Every photo, article, video, and piece of music online is protected, unless the creator has explicitly given permission. Google Images is not a free stock photo site. Myth B, I gave credit, so I'm fine. Wrong. Giving credit is polite. It is not a substitute for permission. If I take your photograph and post it with a credit, photo by you, I have still infringed your copyright. Attribution and licensing are different things. Myth number C, I changed it 20%, so it's now mine. Well, it's wrong. There is no percentage rule anywhere. This is a complete myth. If the core of the work is still recognizable as someone else's creation, it can still be infringement. The question is whether it's substantially similar or not. The last myth is, if there is no copyright symbol, is it protected? Answer to this is wrong. The C symbol is optional. It's helpful. It notifies people that you are claiming copyright. But the absence of it means absolutely nothing legally. Everything created after a certain date is protected automatically, and C symbol is not necessary. Now, remember the quiz at the beginning? Let's go through the answers. Number 1, you post a photo on Instagram. Can someone freely repost it? The answer to this is no. Your photo is automatically copyrighted. Instagram's terms of service allow Instagram to use it, but they do not give every random user the permission to download and repost it elsewhere. Your second question was, your friend hums a new melody. Is it automatically protected? Well, the answer to this is yes, but only once it's fixed. The moment they record it on a phone, write it on music sheet, or save it digitally, yeah, it's protected. But it's only in their head. Like if it is only in their head and never recorded, then it cannot be protected under copyright. Next question was, old song from 1940. Can you use it freely in your video? Well, maybe. In India, if the composer died before 1963 or so, the composition might be in the public domain. But the sound recording, the specific recording of the song, might still be protected. This is why music licensing is so complex. So always verify. The last question was, your private diary. Does it have copyright? Well, the answer to this is yes. Copyright does not require publication. The moment you write those words in your diary, they are protected, even if no one ever reads them. Now, as you can see on the slide, these are the key takeaways from today's lecture. Let's lock in the 6 things to remember from today. Number 1, copyright protects original creative works like writing, music, art, film, software. Number 2, copyright is automatic. The moment you create and fix your work, you own it. Number 3, in India, it lasts your lifetime plus 60 years. And after that, it goes on to the public domain. Number 4, ideas, facts, and titles are not protected under copyright. Only the expression is. Point number 5, fair use allows limited copying for education, research, commentary, and parody. But it is decided case by case. It is not a blanket free pass. And the last point is, credit is not the same as permission. Always get a license or use public domain or Creative Commons licensed work. If there's one thing you take from this episode, it's this. Your creative work has value, and the law protects it automatically from the moment you make it. So treat your work accordingly. So in episode number 3, we are moving into the trademark territory. How do brands protect their names and logos? What happens when two companies have similar names? Can you trademark a color, a sound, or a smell? And how do you register a trademark if you have a business? Episode 3 is especially important if you are a business owner, an entrepreneur, or anyone building a brand. Don't miss it. If today's episode helped you, please give it a like, and it helps more people to find this series. Subscribe so you don't miss episode 3 tomorrow, and drop a comment and tell me, has your creative work ever been used without your permission? I read every comment. See you tomorrow. Take care.